I'm facing this way. You can see me, but you can see me now.
Yeah, perfect.
Perfectly now?
Okay,
Okay,
perfect.
fine.
Okay,
And you can
welcome
hear
back,
me?
everybody. This session is entitled Going to the Sunshine State, Things to Know Before You Get Burned, Considerations in Florida Planning. For this extremely important and timely topic, we're privileged to hear from Adina Lewis and Lawrence Garbuz. By way of background, Adina Lewis is a founding partner at Lewis and Garbuz and has more than 20 years of experience working exclusively in the field of trust and estates. During that time, she has worked on many complex and contested proceedings, both in the United States and abroad. Adina also completed her law degree at the Yeshiva University's Cardozo School of Law, where she served as managing editor of the Cardozo's Women's Law Journal. Lawrence Garbuz is also founding partner at Lewis and Garbuz. He has more than 25 years of experience in the field of trust and estates, with experience serving individuals and institutional clients with personal estate planning, wealth preservation, and estate and tax issues. Lawrence is admitted to the practice of law both in New York and Florida. He also received his law degree from the Yeshiva University's Cardozo School of Law, where he served as managing editor of the Cardozo Arts and Entertainment Law Journal. With that introduction, I'll now turn the program over to Adina and Lawrence.
Oh, good morning, everybody. So I would like to start by first thanking Jonathan Shenkman at ParkBridge Wealth Management, NYU, particularly Alan Sector, for putting this together and offering us to speak. I also want to give a little shout out to Susie Myers, who's head of development at YU, I know for many years, and is a dear friend. My family, I have a long connection to YU. I went to high school there. I went to Cardozo. My daughter is now at college at Stern, and my son was there. And I'm a big believer of it, obviously, in supporting it. But I want to note that even if you had no family connection to YU, us as modern Orthodox Jews, it behooves us all to support and facilitate our clients in supporting this great organization. So it does more than just educate students. It represents all of us in the modern Orthodox world. So I just want to thank them for all they do for all of us. So we're going to talk about Florida planning. But before I talk about Florida planning, I just want to talk about something a little bit off topic for a second, something that comes up in my practice very often and something that I feel is an important issue as a practitioner. I often work with women, especially after they've been widowed or somehow are alone and need assistance in handling financial affairs, as they've never been the ones to handle it before. So, and one would think that younger women of today might have more involvement in their financial affairs, but in my experience, it's often not so. Even last night, I ran a workshop on financial organization, and as I'm talking to the women, all way younger than me, really say, my husband does the finances, and I say, that's fine. But what happens if he's, God forbid, not there? And we need to think about that and how to make people, and women or anybody who handles the finances, actually in my house growing up, it was my mother, not my father, how to make them feel comfortable in that when it's their own personal finances, they should own it as well. Sort of on the same topic, but maybe just opposite of it, is as baby boomers age, a lot of them are successful career women who have a lot of earnings in their own right, and they are very capable of a lot of charitable giving, and they might consider how their trends and how they want to give charity might be very different than men's. And I think that as practitioners or wealth managers and accountants, we should think about that and how to approach it in a way that might be different than you have or traditionally approached it. So those are just my sort of food for thought on all of that, a little bit off topic, but important to me. And I guess it's on topic in that we're talking about Florida, which tends to be people who are of the older age retiring, though not necessarily, as now we talk about taxes. And sometimes we have people moving to Florida for reasons other than just retirement. Okay, so today we're going to cover things related to Florida planning as opposed to New York planning or moving from New York to Florida. We're going to talk about the rules of domicile and statutory residency, the unauthorized practice of law, meaning if you're a New York practitioner, how does that play out if your New York client just moved to Florida? and Florida state planning considerations as opposed to New York and differences, and then homestead protection and asset protection related to obviously asset protection that is beneficial in Florida versus New York. Okay, so let's get into it. Factors to consider and to determine domicile and statutory residency. Okay, so I think we all know anecdotally, it seems clear that many New Yorkers are leaving to Florida. They may be going to retire, but they're also trying to avoid the high taxes of New York, especially since the 2019 federal deductions have limited New York ability to deduct it on federal taxes. That makes it even more beneficial to move to Florida, possibly. So what are we actually seeing? What are we seeing? Are the populations really changing? Well, the answer is yes. Where are the clients going? So again, if you look at the slide, Florida continues to grow. New York is losing population or staying stagnant. Okay, so the blue line is New York. The orange line is Florida. And as you see, it kind of stayed the same in New York and it's rising significantly in Florida. And as you see, sort of 2022, the gap is widening. So what are the most populous regions in Florida that people are going to? South Florida. Counties like Miami-Dade, Broward, Palm Beach, and South Florida has 6.2 million residents. The New York City metropolitan population is presently 19 million. And 2014, South Florida population stood at 5.79 million, a 10% increase, while metropolitan New York grew only by 1%. Again, top cities of New York, only 4 are growing. New Rochelle, one of them, which is close and dear to me. And meanwhile, 20 largest cities in Florida all have seen growth since the last census. Again, 13% increase in Florida and South Florida as opposed to 1% in New York. So New York is losing its tax revenue because of so many people leaving. So it's very much in New York State's interests to go after people who have high wealth who are leaving New York and try to grab back their taxes and get their income or their liability to pay their taxes. Okay, so what are the chances of being audited by New York? Very likely if you're a high wealth individual. I know somebody would say with certainty you're going to be audited. The tax department is sophisticated and aggressive on this, and they have many auditors working on residency issues. So this is a real concern for somebody who's leaving New York to Florida to avoid taxes. Now, these audits can be regarding residency or income allocation. I'm focusing on residency today. So, domicile versus residence. We kind of use those words interchangeably, but actually in the statutes, they actually have different meanings. A domicile specifically means a domicile is a place where someone intends to return whenever they have been absent. A person can only have one domicile. Residence, however, is a place to abode, a place where they live, and they can have many residences. Okay? So just the statute reads, you must pay income tax in New York if A, domiciled in New York, or B, not domiciled in New York, but A, maintain a permanent residence, or B, spend more than 183 days of the taxable year in New York. Right now, I'm going to talk about A, domiciled in New York. There are 2 tests. There's domicile, and then there's the statutory residency test. I'm going to talk about domicile first, and then I'm going to talk about residency second. So let's go back. Everyone thinks 183 days you're out of New York, you're in the clear, no New York taxes. Just not true. So again, there are 2 residency taxes, domicile and statutory. Either one, if New York State finds that you are a domiciliary or statutory resident, you're paying taxes. Basically, all drains lead to New York State owing income or estate tax. We're talking about both income and estate tax. And of course, estate tax can be significant if you don't do proper New York State planning. Okay, so now let's talk about domicile. So as we talked about, the definition used the word intends. So that's something very subjective. And how do we show intent? It's in our head. So New York State says, as an individual seeking to establish a change in domicile, it's the taxpayer's burden to change his domicile by clear and convincing evidence. He has, and which is a high burden, and the burden is upon a person asserting a change of domicile to show that the necessary intention existed. So in determining an individual intention in this regard, his declarations will be given due weight, and they will not be conclusive if they're contradicted by his conduct. So again, how does New York measure intentions? It presumes it by your deeds or your actions. So what they've done is they have put together 5 primary factors to consider to prove or disprove that you are a New York domiciliary. Again, New York has to win on all 5, on one of the 5, I'm sorry, and the taxpayer has to disprove on all 5. So it's a high burden and it's hard, and it's, let's go about how to do it. So again, we look at deeds or actions, and how do you do that according to New York State? Generally by records and documentation. So auditors are looking for, quote unquote, a change of lifestyle. The case law standard is basically the test of intent is whether the place of habitation is the permanent home of a person with a range of sentiment, feeling, and permanent association with it. So how do they do that? I just want to point out something about also how it can work against you on both ways. So this is a well-known case, Dorrance's estate. Mr. Dorrance was the head of the Campbell Soup Company. He believed his domicile, his intention was to return to always be in New Jersey. His church connections were there. He had a residence there. He voted there. He declared in his legal documents that was his domicile. So he wanted to declare himself a New Jersey resident. However, over many years, he had a larger estate in Pennsylvania. He lived in Pennsylvania because his children were, he thought it was better for his children to be educated there. Socially, it was better for them there. And so in the end, upon his passing, New Jersey, as he had declared he was a domicile there, the domiciliary, levied inheritance tax on him from New Jersey. But Pennsylvania also said he was more in Pennsylvania than New Jersey, and that he has all the markings, for lack of a better word, of being a Pennsylvania domiciliary or a resident, and he was taxed on both sides, on both states. That's something, of course, we would like to avoid. So let's talk about these primary factors. So there are 5 of them: home, time, near and dear, business, and family. So let's go through each of them. So let's start with home. So when we're talking about home, we're not talking about just physical residence, but we're talking about a change of community. That you view Florida now as your home. That's where your close friends are. That's where your close ties are. So, but for starters, how do you accomplish this? It's best accomplished by selling your house in New York and buying a house in Florida. Owning a New York home and renting in Florida might be very problematic to pass muster. Give a New York higher value home in a lesser place or a small place that isn't as comfortable as your New York home, that also might be problematic for the taxpayer. So New York will ask, have you left your community? So how do we show that? So things like, have you changed your shul membership? Are you now non-resident status? Have you joined the shul in Florida? How else have you integrated in your Florida community? If you're a president or board member of your Florida shul, that's probably a good proof that you are Florida is your community and you've integrated. Where do you spend your holidays? Just as an example of something that actually happened was New York was auditing somebody who was arguing they were New York domiciliary, and he hadn't been a big golfer, and he belonged to Florida Golf Club, and that golf club kept attendance records. Proving his attendance records sufficed for New York to deem him not a domiciliary. So regarding home best practices, you must give up your New York State home. That's really, you want to visit New York, get a place in Jersey, get a place in Connecticut, or you're less likely to win on this. In fact, you probably won't win on this. Another suggestion would be to rent or lease a place in New York for a limited time so that they can't argue this is your full-time residence, and you are limited, and you certainly can't be over any allowed days because you physically are not, you're not allowed to be there. And of course, that's easy to prove with actual lease or rental documents. Next, business, active business involvement. So if your business is in New York, it's going to be an uphill battle and you're unlikely to convince the New York Tax Authority. If you have ongoing participation and decision-making and frequent communication with a business, even after official retirement, New York may consider you a New York domiciliary. I'm not referring to a passive business interest. I'm talking about, let's say me, a partner at my firm. I talk to my office every day. I look at documents. I respond to clients. I'm actively involved. It's going to be a more uphill battle if my office is based in New York. Next, time. So time we refer to often that 183 days in that residency test, but it also comes up here as well, but a little differently. So New York State starts with the assumption that you spend most of the time where your quote unquote home is. So the number of days is not completely dispositive, on the domicile test. So it's looking more to focus on change of pattern of life, not just the days spent. So you'll need to prove day-to-day location for every day by keeping records, but they're overall looking at this change of pattern. The records you might consider using are things like your diaries, credit card statements, cell phone bills, Easy Pass bills, and the like. But I'm thinking you might also want to be careful if you're somebody who, or if your client is somebody who their children use their credit card, their children use their Easy Pass, so their credit card statement shows them at Starbucks and not Great West Side, and then try to explain that to New York State that that's really your kid, that wasn't you. I don't know, something to think about. So the next factor really is really kind of interesting. It's very subjective, right? It's called near and dear, things that one holds near and dear to your heart, such as pets, artwork, your collections, your family heirlooms. So subjective. So again, it's based on those personal items which enhance your quality of life. Sometimes called the teddy bear test, the things you would never leave home without. So let's consider, where are your Shabbos candlesticks, especially the ones your grandmother gave you, your Kiddush cups, where is your pet? It's actually come up even, where is your pet buried, to determine domicile. So the decision if an item is near and dear is not exclusively based on monetary value. It's about nostalgic, possibly, or family. So consider, for example, the location of your family pictures, your family heirlooms, things that are very special significance to you, your family, things you would never want to have lost. But one of the best evidentiary proofs of this factor might be your insurance rider. An insurance rider is often used by auditors to attempt to verify the location of treasured items. Where does your insurance say you have your valuables? So do not insure them in New York. Do not keep a safe deposit box in New York if you want to prove that you are a domicile of Florida and not New York. So the last of these 5 primary factors is family. So in theory, this last factor is only to be considered after the auditor has not come to a conclusion for other primary factors. But it is one of the primary factors to consider. Things like, where do your kids go to school? This will be an important factor then. It's hard to argue you're not a New York domiciliary when your minor kids go to school in New York. If your kids go to boarding school, where do they go when they are off from school? Where do they go for their holidays? Usually this consideration relates only to your minor children and your spouse, a spouse who's not legally separated from you. But New York State could, in theory, expand that. For example, if you claim and you see your grandchildren every chance you get, you never miss a baseball game of theirs, you never miss a school event of theirs, that might come into play. Some exceptions to this: even if you are deemed a New York domiciliary, if you are really not in New York, you may be able to avoid New York taxes. So there are 2 rules. First, there's the 30-day rule, and the second is the 548-day rule. You're in New York under 30 days, and you have no permanent residence in New York. So again, selling that New York residence is going to be important. And having a permanent residence somewhere else, you may be able to avoid New York tax liability. Or If out of 448 consecutive days, you're outside of the country for more than 450 of them, and your spouse or minor children are in New York for less than 90 days of those consecutive 548 days, you could avoid your state taxes. So, for example, I follow my retirement dream of traveling most of the year. I can, in theory, not have to pay New York state income tax or state taxes if I'm traveling more than I am in New York. And if that is less than 548 days, it has to follow a similar ratio, which ultimately comes out to being in New York around less than 16%. It's about 16.4% to be exact of the time over a consecutive period to avoid tax liability. Some other factors to consider. These are called other factors under the audit guidelines, the auditor's guidelines. They're all things I'm not going to read each one of them. These in theory are they're other, they're not to be considered after the first primary factors. These are only to be considered after the first primary factors are inconclusive. So in theory, you shouldn't have to prove each and one of these things, but that a taxpayer should do them all because they are going to buttress their argument that they're not a New York resident. They are defensive in nature, but they're not going to be determinative of residency. So you should do that. Things like changing voter registration, your safety deposit box that we discussed before, car registration, etc. I do want to highlight one factor that absolutely is not supposed to be considered by auditors or cannot be considered by auditors in determining domicile, and that is regarding charitable giving. You can give money to YU or New York-based charity, you can volunteer in a New York-based charity, and that is not allowed to be a consideration for proving domicile for you. So we should be mindful of that. I think about also in terms of time, you have to come in exclusively to volunteer. How do you do that? When does that happen? I'm thinking in my mind of the analogy of going on a mission to Israel. You get off the plane, you go straight, you follow the itinerary of this 3-day packed-filled day of events on your mission. You go south, you go north, you go visit hospitals. You do that straight for 3 days, you end the mission. You have a closing part of the mission. You get on the plane, you go home. You are literally there doing nothing else but that mission for charitable purposes. And I think that's kind of like the scenario I think of where that works. I'm not aware of any missions to New York City or New York State, but the concept I think you can understand. Let's talk about now the second test, statutory residency. So if you look at the top of the slide, A, we just discussed. Now we're going to talk B, not domiciled in New York and maintain the permanent residence or spend more than 183 days of the taxable year in New York. So your permanent residence or permanent place of abode for the PPA has to be fixed and limited, has no residential interest, and has a particular purpose. And then we're going to talk about what the 183 days is. It's a day to visit New York, which is purposeful and voluntary, but any part of the day will count. And then we're going to talk about those exceptions next. So let's go back to PPA. What is fixed and limited time? So you come to live in New York for a specific purpose, which is limited in nature. For example, you have a trial in New York. You have a consulting assignment in New York for a New York corporation. You're reassigned for a limited sole purpose, but likely that purpose needs to be under 3 years. That is not that you've been assigned to run the New York branch of your law firm or you're a regional salesperson in New York. It's a single assignment, case or matter, a distinct thing. It has to be a particular purpose, and that has to be the sole reason you are in New York. Okay, so what is a permanent place of abode under the New York rules? So one, it has to be quote unquote a dwelling place. So what does that mean? Is it suitable to live in it year round? Is it habitable? Does it have heat? I'm thinking of a bungalow, upstate bungalow, which is not winterized. That is not all year round. It's not suitable for all year round. That should not count. Is it under construction? Are you doing renovations? You can't live there. Does not count. Second, that you have no residential interest, meaning it's not maintained by the taxpayer. It has no specific, and the taxpayer has no specific place in that abode where he or she resides, meaning it's not his or her residence. And in this instance, actually, owner's interest isn't relevant. So, like I'm thinking, for example, your mom co-op is in New York, you live in Florida, and you pay her maintenance. But you don't have a dedicated room or space there. It's not yours. So somebody else's primary living in that space, that is something you don't have a residential interest. As of New York 2022, New York policy is that you have to be quote unquote substantially there all of the year. So often the rule of thumb is under 11 months, or sometimes called the 10-month rule. So a good practice may be if somebody wants to be in New York but doesn't want to trigger residency rules, they would lease or rent their place for a specific amount of time of the year, where you cannot live there for 2 months of the year. So that's easy to prove with a lease or rental agreement. Have a lease that limits you to 10 months of the year. You're only there, but not July, August, for example. Next, let's talk about these days. What is the definition of a day under New York State? Any part of a day is a day for New York. If you're in New York for 5 minutes, it's a day unless it falls into one of the exceptions. Okay, so, and the burden is on the taxpayer, and you're going to require a lot of record keeping to do that, similar to what we discussed before, by using cell phones, toll receipts, credit card statements, travel, your Outlook calendar, etc. So let's talk quickly about exceptions. There are two major exceptions: medical days and travel days. But a medical day is not a doctor's visit, it's not an outpatient procedures. You are in a facility. Travel days, that means you're literally not starting or ending in New York. You're driving through New Jersey to Connecticut. You're going over the GW Bridge from New Jersey to Connecticut, or Tappan Zee, such as, something like that. But you're not actually stopping or starting in New York. You have no purposeful stops in New York. Let me just reiterate one thing about this, about the days, is that if you're going from Connecticut and you're going to JFK, because that had the best price for flights, so there's no other airport nearby, and you're literally going from Connecticut, getting on your plane to somewhere else, that does not count as a day. That is an exclusion or exception. Okay, so these are some considerations. We talked about all the reasons why it might be beneficial, or how to pass muster for New York State in tax liability, to avoid tax liability in New York. But there might be some reasons not to do it. Why? For example, you have your primary residence was in New York, you bought it many, many years ago, you have very low tax basis. And if you were to sell that, you would have very high capital gains tax. There are other tax advantages of having a primary residence. There are advantages in financing to have it as a primary residence. That might be worth a lot of money to somebody, to a taxpayer, and they may not want to give that up. Secondly, if somebody's looking to be Medicaid eligible, they don't have as a robust a program as New York. And if you're looking to have Medicaid eligibility, you might want to be a New Yorker. It might be worth it to you. And lastly, as you see, as I discussed here, there are many pitfalls and many hurdles to actually not be deemed a domiciliary or statutory resident of New York. And it includes a lot of time, effort, stress, and record keeping. Do you really want to stress about how many times you visit your grandchildren, or you want to come to New York to see the opera, you want to be in New York for a certain amount of time? Is it worth it? So, and again, if on the state tax issue is your concern, there are other ways to do tax planning to avoid it. So those are things to consider and think about. And lastly, if you are deemed to be a domiciliary or statutory resident of New York, what happens? You will owe the tax, and there will be penalties, and they can be very steep. Interest generally right now is about 7.5%. And you can be penalized for failure to file, failure to pay, or for substantial understatement of income, or for negligence. And worst case scenario, of course, is you can be criminally liable for being deemed as perpetuating tax fraud. So lastly, just if you are deemed a non-domiciliary, you probably do not have to do audit year in, year out. But if you are a statutory resident, you will have to do this year in, year out, and it can be very cumbersome. So I'm going to give this over to Jonathan now to give you a code, and then Lawrence Garbuz is going to take over in his presentation. But my screen is going to be the one shared for the slideshow, so you can continue to watch that. Thank you.
Great. Thank you, Adina. Right on cue. I was about to interject here. For the accountants and attorneys who are taking this program for credit, please write this down. The code is E26. Again, E as in echo, the number 2, and the number 6. One final time, E26. Okay, back to Adina and Lawrence.
Hi, good afternoon. Excuse me. Good morning, everyone. My name is Lawrence Garbuz. I want to thank everybody who organized today's program, in particular Jonathan Shenkman. I want to thank YU as well. I'm a proud alum of Cardozo Law School. My children go there, and very happy to work collaboratively with the development team from time to time to help clients effectuate their charitable goals. I got my start a long time ago working at a large Jewish not-for-profit, and the topic of client giving and working collaboratively with clients is always near and dear to my heart. But let's start and talk about Florida for a couple of minutes. First of all, I want to acknowledge it's a little hard to present when you're the last speaker, and certainly after the verification code was just mentioned. But I really want to talk about the differences between New York and Florida. And I ask everybody to consider, if you can, the following example. You have very good clients. You've worked with them for many years, and these are people that you like very much. You have a personal and professional relationship with them. You've done estate planning for them for many years. You have worked on the administration of their parents' estates. You have worked with them concerning their children, estate planning for them, or prenuptial agreement. You've done real estate work for them, corporate work. And these are the types of clients you really want to have and you really want to work with. And then one day you get a phone call, really out of the blue, and your very good clients call you up and they say, we're moving to Florida. Doesn't really make a difference why. Most clients say for taxes, but we've decided to move to Florida. And the reason why I start with this particular series of slides is because I want to talk about the ethical and legal obligations of practitioners who are outside the state of Florida, not admitted to the Florida bar, and what can and can't they do. Now, the Florida bar actively and vigorously looks into cases of the unauthorized practice of law. And Florida actually has a statute that makes the unauthorized practice of law a felony, and it is something that we need to be mindful of. Not only do we have an ethical obligation, but we certainly don't want to walk into a trap where we are engaging in the unauthorized practice of law and creating problems for ourselves. Don't let the client's problem become our problem. So what do you do? And let's sort of talk about who can and who cannot practice law in the state of Florida. Well, you know, the Florida Supreme Court has defined that practice of law includes drafting wills, trusts, things like that, and other estate planning documents. If you engage in any of those types of transactions, you are engaged in the unauthorized practice of law. If you're not admitted to the Florida bar, you cannot practice. You cannot establish an office in Florida. You cannot engage in a particular, can't go to court. You simply cannot meet with clients on a regular basis in an office type environment. These are all items that you need to be mindful of. But then the question is, who can't advise clients who are in Florida? And I think that what's important to understand here is that there are a lot of conditions where somebody can advise clients. First of all the attorneys who are admitted to the Florida bar, obviously, were able to advise clients. I'm able to advise clients here in New York and working with clients who are now down in Florida. You can physically be located in the state of Florida, and you can meet with old clients, like in the hypothetical. You can meet with them. You can discuss their planning. You can even meet with them in their home in Florida. You just cannot do it in an office. You obviously can't appear in court while you're in Florida, but you can, in fact, engage in discussions with your clients. Here are my best practices that I'd recommend to everybody who is attending today. First of all, if a client does approach you regarding to Florida work, and you're either not admitted to Florida, or this is not something that is your bread and butter, I recommend that you may want to retain your own counsel in order to review documents, in order to make certain that you're not doing anything that would create a problem for your clients. Admit to your clients at the early part of the discussions, you're not admitted to the practice of law in Florida, and put everything in writing, particularly in those situations where you have a good relationship with your clients. You want to make certain that it is made clear at the very beginning of the planning process for Florida work that your clients receive that in writing. What you also may want to consider doing is retaining co-counsel to work together with you regarding those clients. Best practices for individuals to consider. Now, clients come to me with a certain amount of knowledge as it relates to Florida law, and they always cite to Homestead, how wonderful Homestead is, and it is. Homestead is a wonderful, powerful tool, and we'll get to that in a little bit. But clients also approach me and they say, well, wait a minute here, why doesn't my New York documents, the documents that you prepared for me and that we've gone over draft and version as it relates to those documents, why doesn't it work to Florida? Why do I have to now re-engage you to prepare new documents on my behalf? As Adina mentioned before, it is recommended if you're trying to relinquish your domicile in New York and say that you're now a Floridian, update your estate planning documents that says that you're a Floridian. Use your Florida address. Have all those estate planning documents that we prepare all the time for our clients. Let it comport with Florida law. It will certainly help you upon an audit claiming that you are in fact a Floridian and not a New Yorker. So here are a couple of the estate planning documents that we're sort of going to review, but I'm really here just to sort of talk about the differences between New York and Florida. You know, people say that Florida is the only state that the further south you go is the further north you get. And we seem to be concentrated on 3 counties in South Florida, Miami-Dade, Broward, and Palm Beach counties, and assuming that represents the entire state of Florida. It doesn't. It's not even a majority of the population in Florida. And we also seem to lose sight of the fact that in Florida, it probably has more, the rules there are probably more similar to the neighboring states than it does in New York. We need to be able to represent our clients and understand what the Florida rules are and not necessarily assume how New York may work in the state of Florida. Let's start with powers of attorney. I recommend that all clients over the age of 18 must have a power of attorney. And let's talk about the differences between New York and Florida. Here in New York, we're lucky. We have durable, springy, non-durable powers of attorney, limited powers of attorney. And Florida has that too, but there's one significant difference. Florida does not have springing powers of attorney. Any power of attorney that's signed after September 30th, 2011 cannot bring a springing power of attorney. So that presents a problem for many individuals because they may trust their agent to be able to do what's right for them, but they may not trust the agent to do what's right for them now when they are fully able to handle their own financial affairs. So what can we do? Well, in Florida, we have to rely on a durable power of attorney, but what most practitioners do is they have the attorney usually hold on to that durable power of attorney the same way we would do with a will, and that durable power of attorney be held in an escrow pursuant to an escrow agreement where the attorney holds the document on behalf of the principal and can only release it to the agent. Now, escrow agreements obviously have to be in writing. It has to clearly identify who's the principal, who's making the power of attorney, and who's the agent, who's the individual who's going to serve on behalf of the principal. There has to clearly indicate the conditions for the release of the power of attorney, what are the triggering events. You also need to talk about your own professional practice. Under what circumstances can you transfer the escrow agreement and the documents to a successor law firm? Can you close a client's file even if you're retaining documents such as a power of attorney in your file? Is a client's matter closed, for example, if you hold on to an original will? You also need to talk about issues like indemnification and hold harmless provisions, and all of this does in fact need to be in writing. Now, Florida permits photocopies just the same as New York, except as otherwise provided in the power of attorney. But if you are reliant on a power of attorney, if you want it to be springing, you have to use some sort of escrow agreement in order to protect the client. Now, I like, when I cannot use a power of attorney, let's see what other alternatives we can use. Well, the first thing is that you can transfer all the assets into a revocable trust, and the successor trustee, their appointment will spring based upon certain conditions that may apply. But that only works for the assets that are in the trust. Retirement accounts, for example, cannot be transferred into a trust. And what you may want to consider doing is using the proprietary powers of attorney given by the financial institution for those, in that situation where the principal will appoint the agent, so the agent has the ability to handle financial transactions for that particular account. Also, in situations that may arise, you may want to have clients sign a IRS Form 2848, which is a power of attorney form, so that items can be attended to as it relates to tax matters. I like clients to refresh their powers of attorney frequently, particularly if they're in Florida. I want to make sure that clients have as current powers of attorney as possible. I don't want, in an emergency type situation, a client to present a 2020 power of attorney, and the person who's going to rely on that power of attorney to say, wait a minute here, this is an old document, go ahead and get us a new document. And of course, that is an emergency situation. You can't get them a new document. So I ask clients to refresh whenever is possible. You know, similar to the rules here in New York, as it relates to powers of attorney, I just want to touch on a few additional items. But similar to New York, third parties have to accept powers of attorney, but nothing prevents the third party from accepting the power of attorney right away. They can, in fact, rely on opinion from counsel, and that will be borne exclusively by the principal. Healthcare proxies. Everybody needs to have a healthcare proxy. Let's talk about that. New York, we have our form healthcare proxy. Florida has their form, and there it's called designation of healthcare surrogate. Now, Florida, like New York, everyone is presumed to have capacity, and when somebody lacks capacity, that's when the healthcare proxy in Florida sort of kicks in. But Florida provides for two other situations, which is literally initially boxes on the Florida designation of healthcare surrogate form. One is to permit the healthcare agent to have the ability to make decisions immediately. And two would permit the agent to be able to make decisions immediately, but still give the still give the maker of the healthcare proxy the ability to override what the agent may decide. Again, if you're moving to Florida, have a statutory healthcare proxy. Let's talk about wills. In the area of wills are very different in Florida than they are in New York. And the one item that practitioners need to be aware of is the issue of eligibility to serve. In order to serve as an executor, personal representative in Florida, you must either be family, or if you're not family, you have to be a Florida resident. So we develop relationships with clients for a long time. We may be appointed to serve as fiduciaries for their estate. And Florida will require, as it relates to wills only, Florida will require you need to use somebody else, family or a resident. Those exact same provisions will apply for guardians for incapacitated persons, but the eligibility to serve restrictions do not apply when you're dealing with revocable trusts or agents under advance directives. So what do? Well, a lot of people want to avoid probate in Florida, right or wrong, I don't know, but a lot of people rely on trusts. And what some clients may consider doing is they may have a pour over will, which is something that we use all the time, and that will pour over into a revocable trust. The revocable trust will, of course, include some springing provisions where perhaps the professional advisor is able to serve as the successor's trustee and make decisions on behalf of the beneficiary of the trust. No contest clauses, they don't work in Florida. We rely on them from time to time here in New York, but Florida, they are unenforceable. What do we do? So we do a couple of things. Well, first of all, if a client has multiple children, you could actually break down the estate planning into separate parts, trust for the benefit of each children. But you can actually consider that the, let's call it the disgruntled beneficiary, would have to bear all the costs, the administrative expenses and other costs, in the event that he or she decides to challenge the estate planning. The other thing that you can do is you can use a King Solomon or a King Solomon committee in order to reapportion the benefits amongst children, for example. Or in the alternative, if the Florida resident has real property in New York, the rules here in New York under the State's Power Trust Law will allow the last will to be offered for probate in New York, and New York law would in fact govern. I don't like specifically bequeathing property under a will. I'd like to maintain privacy on behalf of my clients. So I generally rely on memorandums, which we know are ethically binding, but are not legally binding on the executor or the beneficiaries of the estate. Florida does allow for incorporation by reference, but please keep in mind that pursuant to the incorporation by reference, the property needs to be described with specificity, and the beneficiary also needs to be clearly described. You can't just say, I give my ring, for example. Please take one step further. Say, I give this particular ring, define the ring. If there are any stones that are attached, define those, the stones that are on the ring. So there is no ambiguity in terms of which property you're actually referring to. Now, commissions. Commissions are treated a little bit differently in Florida than they are in New York. In New York, if you have a $1 million estate and the probate estate, you'd be entitled to receive $34,000 worth of commissions. In Florida, the same size estate, you would be entitled to receive $30,000 worth of commissions. But the difference is that you would be entitled to receive commissions for extraordinary services. That it will be in addition to the executor commissions that you would otherwise be entitled to. Due execution is not identical. There's witnesses and the notary is notarizing the witnesses. Here in New York, technically all you need are two disinterested witnesses. We often use notaries for the affidavit of attesting witnesses, but that is New York. I recommend use in New York use witnesses and a notary, but for Florida, absolutely use notaries just the same. Otherwise, you may have an invalid will. Revocable trust. You know, many years ago, it seemed like every Florida client or anyone who's intended to move to Florida wanted a revocable trust. And principally, the reason why they gave is they wanted to avoid probate in Florida. We talked about probate in New York versus probate in Florida, and they concluded that perhaps for revocable trust, use them in Florida, not necessarily so in New York. Some practitioners have changed that thinking. Maybe they use revocable trust for both states. The execution requirements for revocable trust are the exact same as it relates to a deed. Now, I like to use for a husband and wife, I like to use two revocable trusts as opposed to combining to a single revocable trust. But I want to talk about creditor protection, because a lot of clients come and they say, well, let's use a trust in order to avoid the rights of creditors. Or they may talk about how they can use revocable trust for estate tax savings. Unfortunately, that's not the case. But Florida is somewhat unique in the fact that they do permit property, perhaps it's located that's outside the trust, to be held by tenancy by the entirety. Husband and wife are able to hold property by tenancy by the entirety. We have that in New York, where real property can be held husband and wife as tenants by the entirety, and the property is protected. Florida goes one step further. They have, of course, tenancy by the entirety as it relates to real property, but I think what's important to consider as it relates to bank accounts, brokerage accounts, those accounts can actually be designated as being held by tenancy by the entirety. You have to indicate husband and wife as tenancy by the entirety, and the accounts have to be established in Florida. Do not use a New York bank or financial advisor here in order to establish those accounts. Be safe. Now, let's talk about the issue of rights of election. We don't permit a first to die spouse to disinherit their spouse. We don't really have forced heirship in this country, but we do force a first to die spouse to leave a certain minimum amount to the surviving spouse. And the way we do that is that the surviving spouse is given the right to elect against the predeceased spouse's estate. Estates can be broadly defined. It's just not probate or just not non-probate. It also includes other property, which is beyond the scope of our discussion today. In New York, the surviving spouse is entitled to a third of the electable estate. But that amount has to be given outright. It cannot be held in a trust for the benefit of the surviving spouse. In Florida, the right of election gives the surviving spouse 30% of the size of the estate. Again, probate, non-probate, and there are, of course, property that is included and excluded in terms of the amount that can be elected against. But Florida is different. If you decide to fund the right of election by means of trust, you can do so. But the amount that has to be given to the surviving spouse has to equal 37.5% of the electable estate. Now, it can go into a trust for the benefit of the surviving spouse, but here are the conditions. One, the surviving spouse has to receive the income. Distributions from that trust has to be based upon an ascertainable standard of health, education, maintenance, and support, a HEM standard. But here's where it's interesting. The trustees of that trust, there is no restriction in terms of who can serve as trustees of that trust. So imagine the following situation: second spouse situation. Husband, for example, passes away, and the husband appoints his children from the first marriage as the trustees of that trust. And of course, there's a conflict there. They can serve as trustees of that trust. And of course, it's going to create an acrimonious relationship if there isn't one already. But I think it's important to recognize, as the surviving spouse, that you may find yourself as a beneficiary of a trust, but the proverbial water faucet could in fact be significantly restricted in restricting your rights to benefit from that trust. If the right of election is not funded within 2 years, then statutory interest can be paid. And similar to New York, the right of election is personal to the surviving spouse. I want to talk about Medicaid just very briefly, because I think we're running out of time. Florida has Medicaid just the same as New York. I think New York's Medicaid is very comprehensive. We get many more benefits here in New York than perhaps we get in the other states. But for a variety of reasons, people move down to Florida and they want to qualify for Medicaid in Florida. That's going to be their domicile. But we have a paralegal here in the office who's a Medicaid specialist. And in advance of today's discussion, we were talking about Medicaid in Florida and clients going either New York to Florida or Florida to New York. And in our combined experience of almost 30 years, we can't remember a single instance where somebody on their own decided to move from New York to Florida, but we can remember many instances where somebody decided to wake up, move back to New York to be with their children and to qualify for either community or nursing home Medicaid here in the state of New York. Emergency Medicaid is permitted, but it is otherwise a whole new application that needs to be submitted. So homestead. Everybody knows about homestead, and everyone knows that homestead will protect the home from certain predators. The right to homestead is enshrined in the Florida State Constitution. But there are some limitations as it relates to homestead, and there are some other benefits that clients just may not be aware of. Let's deal with the other benefits. Let's assume a client has $1 million home in the state of Florida, and let's assume real estate taxes are 2%, $20,000 a year. The house is in a desirable neighborhood, and in the following year, it's now appraised at $2 million, or real estate taxes should be $40,000. Well, Homestead protects the Floridian from the real estate taxes from increasing by more than 2% in a given year. It can increase by 2%, but you can't have this jump between 20 and 40%. You actually have to register with the county clerk's office that you are claiming homestead. You have to own the property before December 31st of the given year, and you have to file by March 1st. And homestead is personal to individuals and only as relates to the principal residence, not to vacation homes, second homes, things like that. Homestead does not work to defeat claims by the IRS, voluntary claims that may be such as mortgages and other financing, and homestead does not work for example, for Medicaid liens that may be filed. Look, I try to review some of the differences between New York and Florida. I strongly recommend that practitioners, in working with their clients, that they speak to them, retain counsel if necessary, in order to do what's right for their clients. There are a lot of traps for the unwary. I try to deal with some of those items that come up frequently. And before we conclude, I'd like to turn over the program to Adina Lewis.
Hi again. I just want to thank everybody for coming, and I just want to give some quick takeaways and summaries of our discussion. So again, we started with talking of domicile and statutory residency, and I hope you learned that it is not just about 183 days. It's much more arduous than that, and we should advise our clients that we should think long and hard about it if it's really doable for them. I want to just point out about how we talked about unauthorized practice of law and how maybe using local counsel or running it by them might be advisable. Again, we don't want to make our clients' problem ours. And lastly, all Florida state planning considerations and how there are differences between estate planning in Florida and New York. We should be aware of them and mindful of them when we are advising clients as they move from New York to Florida. And obviously there are advantages, as we all know, of taxes in Florida versus New York. But again, these are all considerations everybody needs to take seriously, and we don't want to let the tax tail wag the dog. Thank you all again. Thank you for listening. I hope this was informative. If anybody has any questions about anything that we spoke about, feel free to reach out to us. Wishing you all a great day.
Great. Thank you so much, Adina and Lawrence. If anyone has any specific questions, new business opportunities, or any other issues they'd like to discuss, please feel free to reach out directly to Adina, Lawrence, or myself where appropriate, and I'll be sure to include their contact information in the follow-up email to this program. 3 more quick, important items before I conclude this program. First, and most important, later today, you'll receive an email from me with an evaluation form for the program. It will ask you to input the codes that I mentioned here today in order to receive your credit. That email will also go out to all attendees tomorrow morning as well. After that is submitted, in the coming days, you'll receive an email from ACE Seminars with your certificate. Again, please keep an eye out for an email from ACE Seminars. If you don't see that email in the next few days, be sure to check your spam folder. Again, the email with your certificate will not be from me or from Yeshiva University. It will come from ACE Seminars. Just a few more very quick items. I'd like to personally thank Yeshiva University for their great partnership in making this event a reality. If you enjoyed this program and would like to see more of them, please support Yeshiva University so they can continue their great work. I'll be sure to include a link in the follow-up email to this program to help support their mission. Additionally, if you'd like to find out more about Yeshiva University's role as the world's flagship Jewish university, please reach out directly to Alan Sector. He can share more about their work, especially in today's anti-Semitic climate, as well as legacy opportunities for yourself and your clients. And Alan can be reached at alan.sector@yu.edu. And finally, my firm ParkBridge Wealth Management runs approximately 20 webinars a year for accountants, attorneys, and high net worth investors. You can follow my work and get notified of my upcoming events by following me on LinkedIn or on X, Instagram, and YouTube at Jonathan on Money. I also host a weekly podcast also called Jonathan on Money that can be found on Apple, Spotify, or wherever you get your podcasts. And finally, if you'd like to connect with me about this program or other matters, feel free to reach out via email at jonathan@parkbridgewealth.com. And with that, this concludes today's program. Please stay safe and healthy and have a wonderful day, everybody.